Happy Friday and happy holidays, and welcome to today's webinar, Estate Planning and Elder Law Essentials, presented by Elville & Associates Managing Principal and Lead Attorney, Stephen Elville. I'm Jeff Stauffer, Community Relations Director with the firm, and I'll be moderating today's event. How this will work today, if you haven't joined us before, if so, welcome. We're glad you're here. You as the attendee are on mute. However, you do have a voice. When you have questions, please note them in the questions panel in the right-hand portion of your screen, and we'll take time throughout to address them. You received the presentation yesterday from me by email for your convenience to take notes on it if you wish. Now, for CFPs and CPAs and other professionals that are on this webinar today, you may receive 1.5 continuing education hours for attending. So please get me your board ID, and for CFPs, I'll need the last 4 digits of your social security number as soon as possible so I can get your CE approved. Everyone also will receive a post-webinar feedback email right after the presentation. So we kindly ask that you take just a couple minutes to fill out this simple survey to offer us your valuable feedback about the presentation. It's also a great time to request a consultation with Steve for your family, as you may have some planning needs that we can help you with, and we're happy to be a resource for you now and in the future. So I'll also remain on the webinar for a few minutes afterwards if you have any non-legal questions that I can help answer, and Steve is going to answer questions throughout, as I mentioned. So briefly, I'd like to share an overview of our firm and some background about Steve before we get started. We have a lot to cover, so I'll be brief. So we were founded in 2010 by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas. Let me share my screen here. Here at the firm: estate and elder law planning, estate and trust administration, special needs planning, business law, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations. Our mission is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We focus a lot on education here at the firm. Through our planning processes with our clients, we offer well over 100 educational workshops and webinars in the communities we serve each year, and also by way of our accredited client care program. We're the only firm in the state of Maryland that has our client care program accredited through the Client Care Academy in Boston, Massachusetts. So it's a program that is very valuable to many of our clients who take advantage of it. We also focus on 3 ideals here at our firm: client education, collaboration, and compassion. And you should expect nothing less from us anytime that you work with us here at the firm. Also, a little bit about Steve briefly. Steve's work as an attorney for the past 20 years has been centered in elder law, special needs planning, and estate planning. He's a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and again, the use of leading-edge legal technical knowledge. He's a very seasoned speaker, presenting about 75 webinars and workshops and continuing education events every year. Also named to the Maryland Super Lawyers list for a 5th time in 2020, and I think we'll have an announcement soon about 2021. He's also had a featured story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charitable organization he founded in 2014 that we're very proud of here at the firm. If you'd like to learn more about that, let me know. I am the director of that charity, which I'm very proud to be. So with that being said, we're going to get started with a brief poll to get you acclimated to participating. So I'm going to get out of that. And let's see here, where's our poll? There's our poll. Okay, so the question briefly is, what brings you to today's webinar on this December day? And the poll is open, and the questions are, or the answers are: I am new to estate planning and need to get started with my planning. I have documents that need to be updated. It's been many years. I feel my planning is in good shape and just need a refresher. I'm an advisor here to learn to better serve my clients, or I'm an agent for a family member and need to plan for them. So choose what is the best answer for you so we get an idea of who is here with us today. And we'll give just a few seconds for you to note your response. Appreciate you participating. We'll give it about 10 more seconds. All right, we've got about 70% having voted. So we have 0% saying they're new to estate planning. We have 24% saying I have documents that must be updated, 35% saying I feel my planning is in good shape and I'm here for a refresher, 24% saying I'm an advisor here to learn to better serve my clients, and 18% saying that you're an agent for a family member and need to plan for them. So thank you for participating. We do appreciate it. And with that being said, I'm going to turn the controls over to Steve. You're in good hands with Steve. Steve should be able to take charge and show his screen. There you go. It's all yours, Steve.
Thank you very much, Jeff, for that introduction. And I'm just going to hit the right buttons here. And
there you go.
I just want to say hello to everyone. Welcome to our webinar. And thank you for being with us on this Friday morning. I'm in conference room number 3 here at Elville and Associates. So I don't have any windows in this particular conference room, but I know it was a little rainy outside, and I understand there's going to be some rain this weekend, but we're going to make the most of it this morning. And we appreciate you spending your valuable time on a Friday morning with us as we go through estate planning and elder law essentials. So as some of you know who may have seen some of our presentations before, Elville and Associates is known for education and giving people a path towards continuing client education and when we work with people. And so that's what we're all about here. But we also want to give people a path forward to understand the processes and so forth involved in estate planning and elder law. But our core purpose this morning is really just to bring you up to date. We know many of you are concerned. Some of you are concerned about COVID-19. Some of you are concerned about the political changes that have happened recently and what are the federal and state estate tax consequences and gift tax consequences of the new Biden administration that's going to be coming in 2021. Some of you are just concerned about the core elements of estate planning, and you just want to refresh on those things and make sure that you're where you should be. And some of you just want to get 2020 out of the way, I think, and be done with 2020 like many of us do and move on into the new year. So wherever you are, we're here to answer your questions and move through an educational process this morning. So with that said, it's my privilege to educate you, and I'm happy to be with you this morning. I understand we have a lot of people on this call, so I'm going to move right forward ahead. And I just want you to know as we go through, consider this to be an informal session. Jeff is an absolute expert at moderating these webinars. He will be taking questions, and we'll be talking about what to do at the end of this workshop. So feel free to ask questions. We're going to stop at certain times throughout the presentation to answer questions, to take questions. If we don't have the answer to your question, which we probably will, we will get back to you after the webinar. But feel free to just to ask questions, be curious. It always helps us as we give the presentation that people ask questions. So with that said, thank you for being here this morning. I am thrilled to be here with you. And let's move forward now as we talk about estate planning and elder law essentials. So what we're going to cover today is really the following topics. Well, what is an estate plan and what is the process? Actually, some estate plans fail, and what can we do to avoid estate planning failure? How can we avoid having an estate plan that actually doesn't work the way we want to? Wills versus trusts. Many people are concerned about what are the differences between wills and trusts, and what is probate and what is non-probate. So we're going to talk about that. Elder law, taxation, asset protection, we're going to cover those. Those are topics in and of themselves, as you may be aware, but we're going to cover some of the basics, some of the things that I will give you today that I think you should be thinking about as trigger points, especially where we are in history, where we are with politics, where we are with taxes, everything that's affecting us in our society today, including COVID-19, and how to get started. So we're going to talk about how to take the next steps and what we can do to help you there. All right, so when we are doing estate planning, and I know many of you on this call, just looking at the poll that Jeff gave, I know many of you already have done estate planning, so you've been through a process before, and you had your reasons, whatever they were, for doing your planning. But we want to have a purpose. We want to understand why we are planning, as fundamental as that may be. I'm going to take you into some fundamental frames of mind today, of ways of thinking, really getting down to the basics, because we know most people don't plan. And we know even the people who do plan, we know that they don't update properly. So we know, as a general rule of thumb, that about 55 to 60% of people have no estate plan at all. Those are the national statistics. And of the 40 or 45% of people who do plan, they don't really do a good job of updating. We're going to talk about why that is critical to update in today's climate and into the future. So we want to understand these things, and we want to have a purpose. And your purpose may be one of several things. It may be something that has nothing to do with what's on this slide. Some people just want to provide certainty, to really lock down and nail down their planning, as of course most of you do. Many people are focused on a smooth administration. I want to avoid probate, or I want to make sure everything is just as smooth as possible. Some people are focused on cost. We want to minimize the cost of administration. Other people in this day and time are focused on asset protection. I want to protect my spouse. I want to protect children and grandchildren, nieces or nephews. I also want to protect against a bad marriage or divorce for myself or for my children. From creditors and from abuse and predators and so forth. On and on we could go. Some people are focused on minimizing or eliminating taxes. So we're going to talk a bit about that today in one segment of the presentation, because we are at a time of inflection. We are at a time where the Biden administration has proposed new tax changes, and we know the political environment is such that we don't know if those changes are going to sail through or whether there's going to be resistance, depending on what happens in the Georgia Senate runoffs and those kinds of things that are going to happen in January. You may have a special purpose. There may be someone in your life that you have a special purpose in planning for. You have special goals. Maybe those are charitable. So we basically encourage you at Elville and Associates to think through these issues, to take time to think, to take time to have a purpose and a plan, and know why you are doing what you're doing, and then to keep those plans updated. Now, let's talk about this whole notion of why planning sometimes fails, many times why it fails. And this is a kind of a surprise to a lot of people who have never heard this thing talked about before, that a lot of people do planning. They're not necessarily counseled in the highest and best way, or maybe they have a very minimal process, which we're going to talk about. Maybe they had good intentions. Maybe they trusted the attorney they're dealing with. Maybe they were referred to the wrong law firm. Maybe they did planning on an internet site somewhere, but they really didn't think through the entire process. So sometimes planning can fail for various reasons. And we know that none of us would intentionally try to do planning when we knew it would fail. None of us would want our plans to intentionally fail. So we're going to talk about why this problem exists. Well, it really boils down to the fact that most people don't go through a process. Most people go through a very simplified, short process that we are going to call traditional estate planning. And traditional estate planning really has a very minimal contact with attorneys or advisors, and it just gets documents done very quickly, and it doesn't really lend itself to comprehensive planning, thinking through the issues, thinking through all the complexities of what we're living through today and the future. How do we appoint our fiduciaries? Who are they going to be? Does our planning have any flexibility? So a lot of plans are just not thought through well, not to mention the asset alignment, making sure that your retirement plans and your stocks and bonds and your cash and all kinds of other assets move appropriately through the plan. So we want to avoid this whole notion of planning failure. And as you see at the bottom of the screen here, there are many, many years that go by from the time someone does planning, typically, to the time they do planning again or revisit the planning. And maybe some of you on this call, to your credit, are revisiting your planning. So the average is about 19 years at a time. That's the statistic that we are aware of, where someone who actually does planning, which we know are the minority of people, so that's not good, but the minority of people are doing planning, and then even those people are not following up well. So at Elville and Associates, we have developed a process that we're known for, and we've always believed in a process that's more comprehensive to bring people through a process, to bring clients through a process where if you listen to what we say to do and you participate in that process, which also includes, as Jeff mentioned, a client care program. And we are the only law firm in Maryland we are aware of that is a part of a client care program that was actually developed through the Client Care Academy in Boston, Massachusetts. So we are serious when we say a process that we have your cooperation or the cooperation of clients. We are going to facilitate that process to make sure that planning works the way it's supposed to. So that's what we're known for. That's what we are all about. So having said all that, traditional estate planning is what most people experience. They meet with an attorney, or even if they do use an attorney, they just have minimal contact with a process or a system, and we call that traditional estate planning. It's kind of a limited planning model where many of you may have experienced this. You walk away from the experience with a set of documents, and those documents are kind of put away somewhere in a drawer. They're not really living in the sense that you're not really looking at them, you're not updating them. Maybe you're not even receiving updates about the laws and the changes in the laws. So we see that as a very static plan, and that is a plan that lends itself to failure. We don't want to be doing that. We want to be looking at planning, as I mentioned, as more of a dynamic process. We want to have a design and implementation process. Once we get the documents into place after much education and much consideration of the issues, we want to do maintenance and updating, and that's our client care program, where we plug you into a process of education, and you can educate your family members if you're so desirous of doing that. You can keep up to date with the laws, and it's basically a habit that we get you into to participate in this idea that just like financial planning, just like tax planning, we can't just set our estate planning and then forget about it. We have to look at it as a living process, especially with the pace of what's going on in the world today. And if we do all that, then our final administration will be as smooth as we want it to be. It will actually work the way it's supposed to and accomplish our goals. That's what we're trying to do in estate planning. So we call this legacy planning. We could call it whatever we want, really, heritage planning or other names we could call it. But what we don't want is just a one-phase, one-dimensional process. We want to have a multi-dimensional process where emphasis is on education. It's a life process, and where you participate and we participate in a partnership to care about what actually happens to the plan and make sure that it works. So let's define estate planning. And there are many definitions of estate planning. You could develop your own based on your own goals, your own desires. So I would just say, if we were filling in the blanks of this simple general explanation of estate planning, we would say here that estate planning is about leaving your property, or in law, we would say disposing of your property, but leaving your property the way you want to the persons, the people, or the organizations of your choice at the lowest possible cost. Most people would agree this is what they're looking for at estate planning. How do I leave my assets to the persons or organizations that I want to at the lowest possible cost, in the surest way and the lowest cost way? So this is a general definition of estate planning. Now, wills versus trust. Now, this is something that is very common when we go to give workshops, wherever that may be, whether they're virtual or not. People have questions about wills versus trust. I'm going to just stop for a second and say, well, given the COVID-19 pandemic, given what we're dealing with the state of the world, given politics, tax increases that are pending and so forth. My personal opinion is, as a general rule of thumb, don't worry too much about this. If you don't have an estate plan, then I would not be too worried about wills versus trusts. Because of COVID-19, we want to get something in place. We want to make sure that it works, and we want to be practical about it. Now, with that said, there are people who want to avoid probate. 99% of Americans, if you ask them, what is the most important thing to you about estate planning, they will say, I want to avoid probate. Whether they have a good knowledge of what probate is or not, that's what most people will say. And that is important. Many of our clients want to avoid probate, and we do many probate avoidance plans. My encouragement to you today is to get something in place, whether it's a will or a trust, and then we worry about whether or not we prefer a trust over a will and so forth. But let's talk about the basics of wills versus trusts. So remember, a will by its very nature is going to go through probate, because a will is basically something that has to be proved. It has to be proved, and that's what probate is all about. So we're going to have probate if we have probate assets. So let's say we have a will, and let's say everything is in our own name. Let's say I'm a single person, I have a house in my own name, I have a car in my own name, I have a brokerage account and a savings and checking account. All of that is in my own name, and it has no joint owner, and no beneficiary. At my death, those assets are going to go through probate, the process of proving the estate or proving the will, whether I have a will or not. So if I have a will, all of those assets are going to go through probate. If I don't have a will, they're still going to go through probate because they were in my sole name with no beneficiary and no joint owner. So many of you are very educated about that, and you know what I'm talking about. Now, what about my life insurance? If I have a life insurance policy and I leave that to my daughter and she's the beneficiary, is that going to go through probate? And the answer is no. If I have a IRA and that has a beneficiary, will that go through probate? And the answer is no. So some assets are non-probate assets and they don't go through probate. Now, what if I have that IRA and life insurance and I fail to have a beneficiary, which is something we cannot allow to happen? That's just going to be a tragedy, because now non-probate assets are going to go through probate, unfortunately. And on IRA assets, it's almost guaranteed that all of that money, unless it's a Roth IRA, all of that 401k or IRA money is going to be taxed immediately. And that's just a tragedy, because there's no stretch out of the taxation allowed at all under those circumstances, basically. So we want to avoid probate for some people. Other people don't care about probate that much. The cost of probate is something that a lot of people talk about. How much is probate? Well, AARP magazine says it's 4 to 7% across the country. So that includes executor, what we call the personal representatives fees. It includes attorney's fees and other things. As long as it's approved by the court, any fees above that have to be approved by the court. So probate is a structured process. It's something some people don't care about. Other people want to avoid it. We encourage people to avoid it, but only if you're educated about why you're avoiding it. So probate is a process. In Maryland, it takes about 9 months on average. In other places, I understand in Virginia, for example, probate is not as long. It takes place in a much quicker period of time, is my understanding. So probate varies in different places, different states. So this is the probate analysis that we are looking for when we're looking at wills versus trusts. So a will plan is a typical plan that we have a will as our driving force, and then we have powers of attorney. We have advanced medical directives for incapacity planning, for financial planning, for medical planning or healthcare planning, especially now at a time of crisis here during the COVID-19 crisis. Having these incapacity planning documents in place is very, very important. We're going to talk about this more just a little bit. Now, revocable trusts seem mysterious to some people. Some of you on this video call have revocable trusts, and maybe you need to update those trusts. remember that the revocable trust is a substitute for a will. So if you're on this webinar and you're confused about what is a revocable trust versus a will, remember that a revocable trust is a will substitute. If I'm coming to do estate planning and I've never done planning before, I'm going to be looking at two very basic estate planning structures. The will structure, where we know probate assets are going to go through probate, and the will have to be proven in probate to be valid. Or I can say I want to substitute for a will, which is a revocable trust. So a revocable trust, again, is nothing more than a substitute for a will. You could think of it as developing a private contract that avoids probate if it's done properly, and it has to be funded. So this is something you'll see in the middle of this slide. It's very confusing. What does that mean, funding? Well, take my example where I was a single person, or it doesn't matter if I'm single or married, but I'm a person that has a house, I have a brokerage account, I have cash, I have a life insurance policy. Well, for a revocable trust, we want to put the non-retirement assets. We want to put cash, brokerage assets, a mutual fund, savings. We want to put my house, we want to put all of those things inside the revocable trust. And now we have a fully funded trust. So a revocable trust, which I'm going to skip ahead just very briefly to the next slide. If we have a revocable trust plan, now our revocable trust becomes the driving force, and that's a wonderful thing. However, the trust does not work well, doesn't work like it's supposed to, unless we fund that trust or align our assets, unless I take my home and make my home part of the trust. My home has to be redeeded, retitled into the name of my trust. My retirement plan does not go into my trust. So IRAs, 401ks do not go into revocable trusts. And most of you on this call are kind of aware of that as educated people. But if you're not aware of that, we would never put an IRA or 401k inside of a revocable trust. So those are retirement assets. Think of those assets as separate and apart, and those have to be beneficiary designated properly to make sure that assets flow in the way that we want them to flow. So it's our non-retirement assets, savings, checking, money markets, mutual funds, our real estate, and so forth. Those things go into a revocable trust. Now, revocable trusts are not magical. They do not provide asset protection or creditor protection in and of itself. If I am a person and I implement a revocable living trust, I do not have asset protection just because I moved my assets into a revocable trust. So they don't provide asset protection in and of themselves, and they do not provide savings for taxes. But they are nice management vehicles that, if done properly, and remember, done properly means that we have a two-step process. We develop the trust, and then the second step is we have to move our assets into the trust. Elville and Associates is very serious about this asset alignment concept. Whether or not you have wills or trusts, we want to make sure the beneficiary designations are flowing properly. We want to make sure that trusts are completely funded and aligned with assets. That's why we have a funding and alignment coordinator. We have a person here at our firm who's well known. Her name is Mary Gay Kramer. Mary and her staff make sure that your revocable trust, with your help and cooperation, of course, is properly funded and aligned. And then our client care program makes sure that over the years to come, there is a process where you are continuously checking and making sure that your trust, if you do have one, is properly funded. Or if you don't have a trust, we make sure that your beneficiary designations are flowing properly to make sure that assets end up where they are supposed to be. And this is a huge issue because one of the biggest reasons for failure in estate planning is the funding and alignment of assets is just not flowing properly with the will or the trust. All right, so we've been going for a little while now. So Jeff, I'm going to stop. We've been going for about 30 minutes, and I want to make sure that everyone has a chance to ask questions if there are any questions.
Thanks, Steve. We do have a couple questions. and one from the person you're going to be speaking with right after this presentation, I believe. So that question is, how often should we meet with an attorney for updating? Presumably, it's not 19 years.
Thank you for that question. So a very broad answer on that. So let's say that we are dealing with a younger person or a younger couple, someone between 35 and 45 years old. Most of the time, if that person or that couple were to revisit their planning within 5 years, just to update names, addresses, and so forth, that would be sufficient under normal circumstances, because this is a young person, and we know that about 80% of people under 45 don't have a will. So these people are doing really well if they have an estate plan. But if we are 45 or 50 or older, we want to update planning every couple of years. Now, some people hear that and they say, oh my goodness, that's pretty frequent. Why would I have to come back and revisit my documents every couple of years? Well, remember, you don't have to, but remember, best practices are to do this. So think about the estate tax changes we're going to talk about in a minute that are now being on the forefront. Think about the changes to the spousal elective share law, which many of you may not know about, but that's something that's pretty big in Maryland, and that's occurred this past year. Think about COVID-19, and think about what we're going to talk about next soon about it, the advanced medical directives, and some of the ways to think about those differently because of COVID. These kinds of changes in life seem to be happening more frequently, and there are other examples I could give you. So the ideal thing to do is to revisit at least every 2 years, and of course to have continuing education every year. And this is not going to be something everybody feels they have time to do or want to do. We want to make it easy for you by providing electronic materials and written materials and our newsletter and access to our client care program and other things. So thank you for that question. I would say on average, if we're 50 years of age or older, we want to revisit planning about every 2 years, just to make sure there's no changes in the laws and to make sure that all addresses, phone numbers, and so forth are updated.
Thank you, Steve. Question from a good longtime client of ours. Does a joint checking account need to be in the trust?
Great question. So when we are dealing with a trust, the question becomes, are we going to go all the way and put our checking account inside the trust? And I would say, in a perfect world, we want to have a checking account owned by the trust. We want to have everything in the trust because the whole goal was to avoid probate. Now, in years past, certain banks were not happy about having trust checking accounts, but I haven't heard too much about that recently. So my assumption is that your bank would allow a revocable trust to own your checking account. Now, with that said, there are couples that have a joint checking account and they have a trust, and they say, well, on the death of one of us, because it's kind of unlikely that both of us would die at the same time, even though that could happen, God forbid, but we're going to just go ahead and keep our checking account outside of our trust, because on the death of one of us, the survivor will inherit that by joint ownership, and then he or she can decide whether they want to put that into the trust. But right now, we've had this trust for 25 years. Our incomes come into that, we've had that account is what I meant to say for 25 years. Our incomes are coming into that account. We pay bills out of that account. We just want to leave things alone. So I think it's a judgment call. And I think as long as you don't keep large amounts in your joint checking account, it is okay, in my opinion, to leave it out of the trust until the death of one of you, and then the survivor of you can put it in the trust, in my view.
Thank you, Steve. Those are all the questions for now.
All right, so we're going to move on. Thank you for those. Now, we know that if we're using documents, which the vast majority of people do to pass their assets, we know people use wills, we know they use trusts. Now, why do the vast majority of people do that? They use wills or trusts because they know that they can ultimately control how the assets flow down to the beneficiaries. If we use devices like these, and many of you are aware of these, joint ownership, beneficiary designations, life estate deeds, where you can actually have a property flow directly to what we call the remainderment, or something akin to beneficiaries. Transfer on death designations. These are brokerage account designations. If I die, my beneficiaries automatically get the brokerage account with no probate. This is a wonderful thing. POD, payable on death from a bank. Same thing, no probate. Or in trust for accounts, which I've seen those in some of the northern states like New Jersey and Pennsylvania and New York. These are basically like POD or TOD accounts. So we want to understand that there are ways to leave assets with no probate and not use a trust. But most people will use a will or trust, vast majority of people, because if we don't, these devices, although they avoid probate, they don't allow us to plan for contingencies. They just are what they are, and they tend to leave assets in a very, very direct way, regardless of whether that is what we really wanted or not. There are ways that assets can flow that are outside of our control due to unexpected circumstances or unpredictable circumstances if we go outside of the realm of a will or trust. Now, with that said, we do use these devices, what I'll call non-probate devices. We do use them in elder law planning, and we do use them strategically in certain types of planning in conjunction with wills and trusts. Now, every once in a while, there's going to be a person, maybe one person out of 100, where this kind of planning here with no will and no trust works very well for them. But otherwise, we are going to look at these, and on the legal side of things, we're going to look at these as tools that we use in certain situations for certain strategies, and not necessarily as the entire estate plan. But those things do exist, and we have wills, we have revocable trusts as basic estate planning, and we have these devices that can leave assets without probate. Now, we talked just a few slides ago about what in the world would happen if we have this will or trust, but we've used these devices and, well, we didn't really understand what we were doing, or maybe we did, but probably if we have a will or trust and we still use these non-probate devices, we probably didn't really have a good understanding of what we were doing. So let's just look at this slide and the next one, where, and I'll just go back and forth a couple of times. Some of you have seen these slides before. We can have the best will or the best trust in the world. We've got this wonderful document. We might have even spent time developing it, having the proper education, going through all the motions and feeling really good about this wonderful document. But look what happened on our death. We had assets titled in certain ways, joint ownership, or we had a bank account payable on death. We had things transfer on death. We had our IRA beneficiaries straight to individuals, and that was probably okay, but maybe we wanted to leave it in trust. We used a life estate deed to pass our real estate on instead of having our home or our real estate inside of a trust. So my point is, look at where the arrows are flowing here, and you'll see that if we're not careful, we will miss the mark, and our funding and alignment will not work properly. So the point of these two slides is this: the alignment of assets, or what we call funding, is one of the most important things in estate planning and elder law. It's not how good the documents are necessarily. It's not how good the will is or how good the trust is. It's where are the assets flowing, and are the assets flowing in concert with the estate plan? So arguably, if you said, what is the most important thing in estate planning and elder law? It could argue, in special needs planning, arguably it is how do you own your assets at the time of your death, and are they properly funded in coordination with your will or trust? That is probably one of the most important things in estate planning and elder law. All right, so that's a whirlwind of information, and up until this point, if you didn't know a lot of those things, you probably know 95% more than anyone you know about wills and trusts and why you plan a certain way and how you can accomplish success through a process. Now I'm going to turn my attention to incapacity planning. So we're on time. We have plenty of time for questions. I'm going to launch now into advanced directives, powers of attorney, and we're briefly going to discuss the MOLST form, the medical order for life-sustaining treatment. So whether you have a will or a revocable trust plan, or whether you use non-probate devices to leave your assets, we want to have powers of attorney and advanced directives for incapacity planning. Now, many of you have these documents, and we want to encourage you to update them over the years. Even the Maryland Statutory Power of Attorney, the one that came out in 2010 that you'll see here, that one is a statutory form. It's enforceable by law. Even that one has been updated over the years 2 or 3 or 4 times. So if you have that form and it's an older one, we want to update that. You'll notice that most of the time we believe in layering that form with a second power of attorney that we're going to call the general power of attorney, so that if you become incapacitated, you have the statutory power, which is fairly limited, and its utility is fairly limited for various reasons, but it's still very much something you should have. And we want to layer that with the general durable power of attorney, so that you have the full force of whatever powers you want to give to your agent. So switching to the healthcare side, we want to have an updated advanced medical directive to talk about who your agents are, and we're going to come back to that in a second. What are my end of life decisions? Do I give flexibility to my agent to change my decisions or be flexible? What are my final arrangement preferences? Do I want to be an organ donor? When does this power become effective? And we're going to talk about that before I leave this slide as well. So why do we do all these things? Well, we are very likely to become incapacitated, unfortunately, during our lives, and we're living much longer. So we want to look at this incapacity planning as really how much flexibility do we give our agents? Do I want to avoid guardianship? So you'll see here in the middle, we've crossed off the nasty word guardianship, because if we're healthy and well, and we hopefully want to continue to be healthy and well, we want to avoid a situation where we lose our legal rights. So in powers of attorney, advanced medical directives, we're appointing agents for our financial affairs, agents for our healthcare affairs, and by having agents, we're avoiding guardianship. And we're doing as much as we can do to ensure that we have our own right of self-determination as long as possible into the future. Now, there are ways that we can still end up with a guardianship, but we're doing everything we can to make sure that there's an 80, 90%, and hopefully 100% chance that we will never have a guardianship of our person or a guardianship of our property. So the good news is that these documents are easy to implement, and we're going to talk about the way to get that done here at the end of the workshop. Now, I mentioned just a second ago, we were going to talk about when do the powers go into effect. So traditionally speaking, clients come in, they look at these documents, and we counsel people on these, and we say you have 2 choices. Basically, you can have the power of attorney or the advanced directive agent power go into effect immediately. And of course, a lot of people do decide that. But a lot of people also decide to make the power of their agent contingent on their disability. I don't want that power to be immediate. I want it to be only effective sometime in the future when I'm disabled. Now, how does that power go into effect? Well, it goes into effect, unfortunately, when 2 physicians certify that you are disabled and you cannot make your own decisions. You are mentally incapacitated, basically, and you cannot make your own decisions. Well, what do we know about COVID-19? We know that COVID-19 is a situation where we may not be able to access, or your agents may not be able to access, those certificates of incapacity. So if you're on this call, one of the most important things I can convey to you about the nature of what we're dealing with today with COVID-19, if you have powers of attorney or advanced medical directives that are contingent, the power of your agent is contingent, which in the past was something that we counseled a lot of people about, and many single people and a lot of married couples will choose this contingent power for either their primary agent or their secondary agent. If you've chosen that in your documents, you are probably at risk that you have a set of documents that won't work in the period of COVID-19. We would need to challenge you to think about making those powers immediate, even if you wouldn't normally do that under normal circumstances, because you might have feelings that, hey, I don't want this power to be immediate the moment that I sign it, subject to the good faith of my agent. But I'm urging you to consider that in the age of COVID-19, we want to have immediate powers, if at all possible, because we may be facing a situation where contingent powers may not work at all, given the state of hospitals, the inability of your agent to access the ability to get you certified as being incapacitated under those circumstances. So that is a tidbit that I will throw out there that is important for you to walk away with and think about today. Again, we talked about avoiding guardianship, and that's exactly what we're going to do when we have powers of attorney and advanced directives and we have agents. You also are doing everything you can do to avoid guardianship when you have a revocable trust plan. So one of the things that is an advantage, theoretically, of having a revocable living trust is the trust assets, which are owned inside the trust, those are controlled by a trustee. So if you become incapacitated and you are the grantor of a revocable trust, you have a guardianship avoidance by having a trustee step into your shoes and take care of your affairs. And for your non-trust assets, you have the financial agent under the power of attorney taking care of the non-trust assets like your 401k or IRAs. And on the healthcare side, you have your healthcare agent. So you're avoiding guardianship even more theoretically with a revocable living trust. Now, wrapping up about powers of attorney, and we're not going to get into too much about these following slides, but I just want you to know that there are two statutory powers of attorney in Maryland. These are powers of attorney that came out in 2010 under the Maryland Power of Attorney Act. And the Maryland Power of Attorney Act was implemented because there was a lot of fraud and abuse and just very loose laws around powers of attorney where agents were not accountable, they didn't have to be accountable, and some very bad things were happening. So the state of Maryland tightened this up. We now have a statutory power, and that statutory power of attorney is enforceable by law. DC has a statutory power of attorney. New York has had one for many, many years. Delaware, West Virginia, and some other states. So this is a very good thing in my opinion, but the simple Maryland power of attorney is not enough. That's the one that we generally use for estate planning. All clients, in our opinion, should have the what we call the short form statutory power of attorney, but it's a very limited power of attorney. Now, there is a power of attorney, a statutory form that is what we call the long form. And that one is very comprehensive. It has a lot of powers. The problem with these forms is they, in our view, they can't be very, very customized. So when we're doing advanced estate planning or very high level basic estate planning, we want powers of attorney that can be customized. So the simple power of attorney is not enough. It should be layered because neither the simple or the broader power of attorney, if they're the statutory forms, neither of them can be customized. So we use the simple statutory form most of the time, and we layer that with a general power of attorney that we can customize. And the following slides, which I'm not going to put you through all of these, but they're for your education, these are some of the reasons why the simple power of attorney is not enough. And we want to make sure that if we're doing incapacity planning, we want to make sure that we're giving your agent as broad of a platform to take care of your affairs as you're comfortable with. Some people are not comfortable with this broad platform, so we're going to make it more of a limited platform. But we want to provide the flexibility that is needed at a time of incapacity, especially now. And so we want to encourage you to customize your general durable power of attorney. We want to encourage you to customize your advanced medical directive and basically to customize all documents that you are doing. Not everybody has the time to do that. We are here to help you work through those issues. So I'm not going to spend much time on that. We're now going to talk again, just very briefly, about when are powers of attorney or advanced directives effective. So we're going to cover this one more time. It can be effective immediately, or it's effective only upon your disability. And as you'll see on this slide, we at Elville and Associates, we have an arrangement for powers of attorney where we will hold the originals in an escrow arrangement if it feels to you like you don't want to give your agent access to the original documents. So many times we will hold documents in an escrow arrangement until your agent needs that. But going back to what I said earlier about COVID-19, we generally want to recommend right now that for powers of attorney and advance directives that you think in terms of making them to be effective immediately, the authority of your agent to be effective immediately under these COVID-19 conditions, and not have them as springing, as you see at the bottom here, springing or contingent powers. Advanced medical directives, these are sometimes the most important document for clients. Clearly here we have a situation with COVID-19 where it's time to look at your advanced directives if you haven't looked at them recently. Does your advanced directive offer or authorize, I should say, experimental treatments? We know President Trump, for example, when he contracted COVID-19, apparently he was given an experimental treatment. This is something that you want to think about. What do I want to say in my advanced directive about COVID-19 related issues? Is my power of my agent effective immediately? Have I customized this with everything I want about my personal preferences? Do I eat certain foods that I'm going to want to have? How do I feel about ventilation? All of those things that we know would happen with COVID-19, even if we're non-medical persons, we just know from what we read, this is what happens if we contract this virus. We want to update these advanced directives to be contemporaneous with what's really happening in the world. So just know that we highly recommend these advanced directives be customized, that you think through these issues, and we will give you the tools to do that if you cannot think through that yourself. The MOLST form is a form that Maryland is one of only a handful of states that requires a MOLST form, a medical order for life-sustaining treatment. So we know that if we go into a facility in Maryland or a hospital, we are going to get one of these MOLST forms. And now this has been in effect for, I'd say about 7 or 8 years now. And many of you are aware of MOLST or have experienced this. If you live in a continuing care retirement community or know someone who does, most assuredly they are required to have a MOLST form. So this is an educational process. This is something to be aware of. When is a MOLST form going to be issued? Well, it's supposed to be issued within 48 hours of you going into a facility. When we go into a hospital, even though it's not required by law, we know we're still going to get a MOLST form. And that MOLST form is a medical order. It's going to be completed by a physician or a nurse practitioner. So we want to be aware of this, and we want our agents to be educated and understand what a MOLST form is, because 9 times out of 10, the staff, the doctors, the nurses, they're going to be acting upon this MOLST form rather than your advanced directive. That does not mean the advanced directive is not important. It is vitally important for you to set forth your personal preferences and wishes, because it's the only information that your agent has or that anyone has to know what your basic preferences are. But we also want to be aware of the MOLST form and make sure that you've had an opportunity to address the MOLST form. You'll notice here that there's something called a healthcare decision worksheet. And that's something that, in my opinion, you can customize how someone should view your ultimate MOLST form. So this is a complex subject. It's too much to get into in this workshop, but I just want to make sure that I'm emphasizing the fact that the MOLST form is something that is part now of Maryland healthcare decision making, especially during COVID, and we want to make sure you have that information. If you are not familiar with MOLST, Jeff and I can send you a MOLST package, we would call it, of information that you can also find on the Attorney General's website. So just know that this is a kind of a companion piece of education to the Advanced Medical Directive. All right, Jeff, I'm going to stop again. I think we've been going now almost another 25 or 30 minutes, and we'll see if we have any other questions.
Thanks, Steve. We do have a couple. First question is, what do you do if any and all of the people you trusted have passed or are no longer available for use either as beneficiaries or agents, etc.?
Thank you for that question. And I'm so sorry to hear that that has happened. We see this quite often. And all I can say as a piece of counseling that we would talk about eventually in person, hopefully, is we will help you work through that. We would start with, do we have friends or other relatives? I know you were very clear in your question that everyone has passed that I would consider, but we really have to dig deep. Are there people that we may not be thinking about? Is your CPA someone who could serve in that role? Is your attorney, your financial advisor, will their broker dealer allow them to serve in that role if you were inclined to choose them? On the healthcare side, we find that sometimes life care managers will be willing to serve as either the healthcare agents or they're willing to serve as consultants to someone that you might end up having to appoint that you wouldn't normally appoint this person, but now you're forced into a situation where you're needing to appoint a third party, so to speak, and they can consult with that life care manager, or what we used to call a geriatric care manager, a nurse, or physician or nurse practitioner who can help make those medical decisions. So there are ways of customizing the documents and ways of working through this. And I shouldn't forget to mention, excuse me, that some financial institutions like banks will serve as a financial power of attorney. So not all of them, but some of them will serve. So we would work through those issues with you and really come to some conclusions. I've never had that situation as encouragement to you. I've never had that situation where we couldn't find a solution. So I just want to encourage you that solution can be found.
Thank you. And the last question, same question from a number of different questions from the same person, but I'm going to try to just round it out here. Has a concern about sharing documents with another law firm and did not use that law firm and has concerns about trying to get those documents back. Is there a best practice as far as trying to get that information back? He has a concern about that information being out there in the hands of somebody that doesn't necessarily need it. Can you just speak to that briefly?
Gotcha. Well, understood. So my initial reaction to that question, even though I don't know all the facts, is if you shared original documents with that firm, those are your documents and that law firm has an obligation to give those back to you, whether they courier them back to you or you go pick them up if it's safe to do so, or they send them to you in the mail, which is something I would not recommend. But that law firm has an obligation to give those back to you. Now, if you just shared email documents or something with them, then I don't know what you'll be able to do about that because you've already shared that information. But originals, I would encourage you to definitely tell them this is my property, these are my documents, and they must give those back to you.
Thank you, Steve. I think that is all for now. Let me just double check. It is. Thank you very much.
Thank you, Jeff. Okay, entering now into the last third and the final part of our presentation. Let's switch gears now and talk about elder law versus estate planning and what is the difference? Well, a lot of people are concerned about elder care issues, obviously, and elder law encompasses a lot of things: housing, disability planning, Medicaid planning, public benefits, SSI, special needs trust. It's quite broad. So, and veterans benefits, as you see here. But let's just go through the bullet points of this slide. What is the difference between estate planning and elder care? Well, in elder law planning, we're generally focusing on disability planning. I have assets, but I don't want those assets to be spent down in a nursing home situation. I want to preserve assets so that I have assets for assisted living. I don't want to ever go to a nursing home. It's disability focused instead of just tax focused. Now, our average elder law client these days is a person that has more net worth than in years past, obviously, because many people have become wealthier in the stock market and other investments that they've made over the years. But the fundamental difference remains the same. In estate planning, we are generally focused on how assets are going to flow to the beneficiaries, of course, with an emphasis on income tax and estate tax planning. With elder law planning, many times we're not as focused or not focused at all on estate tax or gift tax planning, even though that is always a part in the background, it's in the background, but we're more focused on income tax planning most of the time and disability planning. How do we protect assets? So now I'll get to the next bullet point, asset preservation. So Elville and Associates can counsel about, do we do conventional estate planning, wills, trusts, and so forth, or do we want to do Medicaid planning? Do we want to divest assets in a certain way? Whether we have an impaired spouse, or do we have children that we want those children to inherit certain assets that we don't want to be spent down in a nursing home type situation. So we use Medicaid trusts and we use veterans benefit trusts. And those are things that many people look at now for various reasons. The next slide or next bullet point here, flexibility. We want to build flexibility in elder care planning, especially. Now, we want to build flexibility in all planning, but especially in elder care planning, because if we become disabled or incapacitated, generally speaking, we want our agent to step into our shoes and do the same thing that we could do if we could do it ourselves. Now, there are limits to some of these things that we may not want people to be able to do, but generally speaking, if we want the full gamut of flexibility, we're going to give our agents massive amounts of power. It's not appropriate in all situations, but basically that's what we're going to do in elder law. Divestment of assets. Do we want to give away assets in advance of an illness, or are we already in a crisis situation where we are going to divest assets and still save some of the assets, even though we're in a nursing home situation? So these are things that we do in elder care. Sometimes when we're using Medicaid trusts and veterans trusts, what we're doing is moving assets from the client to a trust, and now the client can maintain some control, even though they have, in essence, given away the assets. And many of you have heard about this, gifting the assets into a Medicaid trust or a veterans trust 5 years in advance of a crisis. So many people do conventional planning, but then they want to know, how can I do this elder care related planning? For some people, this is a topic of interest. And so what we want to do in elder care planning is be able to divest assets in many circumstances, but still retain control and still provide asset protection of the assets, still get a cost basis adjustment at death. So Uncle Sam's talking about taking that away. We're going to talk about that in just a second. But we want to make sure we get a cost basis adjustment, meaning that our children or nieces and nephews or grandchildren, our spouses, receive assets at a new fair market value, at a stepped up basis. So in elder care planning, in a perfect world, we want to achieve all those things if we can. Medicaid, there are various types of Medicaid. There's community-based Medicaid. There is long-term care, skilled nursing Medicaid, which is most of the time what we're dealing with. And then there are the Medicaid waiver programs, which Maryland does not do a great job with. And that is a source of continuing frustration. So in elder law, we're looking at all of those Medicaid concepts because Medicaid is an umbrella that covers most long-term care. So we have to plan kind of in conjunction or coordination with this umbrella. And for veterans, in the fall of 2018, the Veterans Administration tightened up the VA aid and attendance benefit, tightened up the qualifications for that. In some ways made it better, in some ways made it worse to be able to qualify. But this is all part of what we do in elder care, including special needs, where we are kind of getting away from the conventional norms of estate planning, which are estate tax, gift tax, and just the disposition of assets. Now, let's talk about the new environment in estate tax planning. And many of you are concerned about this. Tomorrow, which happens to be our December 5th Client Care Program event, this is our last Client Care Program event of the year, we're going to be talking about the end of year 2020 tax planning issues. I won't be able to get into all of those things right now, but I will give you a very brief overview. So I read President-elect Biden's proposed tax plans, and it was about this thick. I read it a couple of months ago, and we all know that it's been a tumultuous political time. We know that President-elect Biden is going to go ahead and succeed to the presidency, ascend to the presidency, I guess. And we know that the Senate, the control of the Senate is still up for grabs with the Georgia Senate runoffs. So we just don't know what is going to happen with the estate tax exemptions. So our current estate tax exemptions for federal purposes are 11.58 million per person, or more than 23 million for a couple. And through portability, which you'll see here, a couple can use both of their exemptions for the maximum amount of the exemption amount, meaning a couple can exclude up to $23 million of estate tax exemption through the use of portability. So we know that. Maryland's exemption is $5 million per person. Now, President-elect Biden's proposal is to potentially cut the estate tax exemption down to $3.5 million per person. We really don't know if that's going to happen. We know it would be about $7 million per couple. We know that right now the federal exemption is slated to be $11.7 million per person in 2021. So who knows what will happen? Who knows whether the Senate will be controlled by the Republican Party or the Democrat Party, and whether the Democrats could, if they were in control of the Senate, could push through all of their estate tax agenda. So we are up against a situation where we may have, we probably will have higher income tax rates, where we will go back to a 39.6% income tax rate. We are going to have higher capital gains tax rates, most likely, depending on who controls the Senate. We are going to have lower estate tax exemptions, most likely. We're going to have to deal with all that. And on top of that, President-elect Biden is proposing the potential elimination of the step up in basis. So we know that all of those things are happening. Now, we've never seen the elimination of the cost basis adjustment except one time. And I believe that was around 1980, and it happened for 1 year. So it's not widely believed that this elimination of the cost basis adjustment is actually going to occur. So I don't want you to worry too much about that, although it's a possibility. There's no guarantee that, there's not to say that even if it did occur, that there would be an exemption. So the last time this was proposed, there was about $1 million of capital gain exemption, or $1.5 million of exemption for capital gain, even if the cost basis adjustment were eliminated. So just to say that it's thought that this is not actually going to happen, but it's something that's on the table. Excuse me, I'm going to take a drink of water. So many people are planning for end of year tax planning right now. It is late. It is probably too late to do certain types of estate and gift tax planning before the end of the year, but it's not too late for everyone. So if you would like to talk about this, this is something we certainly could talk about. One piece of good news, if we want to rely on experts, is I had occasion to speak with a nationally recognized preeminent estate and gift tax attorney yesterday, who's doing lots and lots of end of year estate and gift tax planning. He personally does not believe that there will be a retroactive tax back to a change in the estate tax that would lower the exemptions retroactively back to January 1st, 2021. He does not believe that will happen. He believes that is very unlikely, and that there's only maybe less than a 1% chance that would happen. So that is a piece of good news if you like to rely on the advice of these kinds of experts. With that said, a lot of people are taking the very conservative approach of making large gifts and using their exemption before it might go away in 2021. The second most likely thing to happen, in his opinion, is that in April or May, or maybe as late as September or October, there might be an estate tax exemption change going forward from the time that it is introduced, but not retroactive back to January 1st, 2021. In his opinion, the most likely thing that will occur is that there will be a reduction in the estate tax exemption amounts, and there will be a new date, January 1st, 2022, that would be the effective date for people who die after January 1st, 2022. So hard to say with the Georgia Senate, Georgia runoff situation. the state of the US Senate and who's going to control that, the new administration. It's hard to say what will happen, but many people are concerned about whether or not they should make end of year tax planning gifts. So if you're concerned about all that, please let me know and we will be glad to talk to you about that. But based on the advice of some of the national experts, this may not be something we have to be so concerned about that we need to rush. And we'll be talking about that tomorrow at our December 5th client care program. Now, in estate planning, in advanced estate planning, we're concerned about, do we want to have marital control? Do we want to protect against remarriage? Do we want to protect the shares of children and so forth? And that's going to lead to our next slide, where we're kind of getting away now with from the concept of elder law in our last slide. And we're really talking about estate planning, conventional estate tax planning, although many of the same techniques, and this is very nice about the elder law world today, many of the same techniques to protect spouses, to protect assets, to protect children and grandchildren, those can be used in either elder care plans or conventional estate plans. As I start to wrap up, and I'm going to look at my time here, looks like we have about 20 more minutes, Jeff. We're going to start talking about some concepts related to asset protection, which is one of the big issues today. So I want you to think in terms of 3 types of asset protection, not just one. I want you to think in terms of lifetime asset protection. What are the asset protection features or benefits that I enjoy right now that I may not even realize I have? What is long-term care asset protection? We touched on this just a little bit a few slides ago, but I want to give you a more in-depth analysis on that. What is asset protection at death? How do I do asset protection for my beneficiaries, for my loved ones? So the good news is here at Elville and Associates, we have a process where we educate you about all of these issues. We want to make sure you understand the basic concepts, if not the advanced concepts, and we want you to know what choices you have to do these things, not just to give it to you as an academic education. We want you to know what your choices are and should you implement some of these things and not just know about them. So let's talk about lifetime asset protection. Now, this will be a very good topic for many of you because many of you don't understand maybe that you already own assets that are that have some asset protection. So for those of you who are single, I'm going to apologize for just a second because I'm going to focus some of this on married couples. So I apologize. But if you're married, you can own your real estate, you can own a brokerage account, basically anything except an IRA, you can own it as spouses, tenants by the entirety. That gives you a very basic level of asset protection. It doesn't cover you in all events, but it is something to be taken seriously. And Maryland law now says if you are a spouse and you are establishing a revocable trust, for example, you can move certain assets into that trust and still retain your spousal tenants by the entirety protection. So that is something that we take seriously. We encourage you to work with your broker dealers and financial advisors to make sure that assets are titled, if you're married, titled as tenants by the entireties before and after we move, or before we move them into a trust. And if you don't use a trust, we want to have that basic spousal protection. Life insurance is protected whether you're married or single. Life insurance is protected as long as your spouse or child is the beneficiary. So the life insurance proceeds and the cash value of life insurance is protected from creditors. Annuities are protected under the same laws in Maryland if your spouse or child are the beneficiaries. Qualified plans, 401ks, 403bs, and so forth, those are protected from the claims of creditors. Now, IRAs are a different story. IRAs are protected up to $1 million according to the bankruptcy laws. And there are circumstances where interpretations of the law say IRAs are protected no matter how much is in them. So those are good things during your lifetime. The problem with IRAs is after we die and we leave IRAs to other than spouses, if we leave IRAs to children, grandchildren, and friends and relatives, we are going to have a situation where those IRAs are not protected from the claims of creditors, according to the Supreme Court. So we want to make sure that IRAs are going into further trusts if we want them to be protected from bad marriages, bad spouses, divorce situations, car accidents, bankruptcy, and so forth. And then we have domestic asset protection trust, which is beyond the scope of this call today. But many people, for example, who are people of wealth that are making gifts right now before the end of 2020, many of these folks are using Delaware trusts or Nevada trusts or Alaska trusts or South Dakota trusts or one of the 14 or 16 states, or maybe up to 18 now, states in the United States that have asset protection laws where you can actually put money into one of these trusts and have asset protection under the laws of that state. Maryland is not one of those states, but it's part of lifetime asset protection that you should be aware of. Asset preservation for long-term care. So we talked about elder care for just a minute, a few slides ago, and just know that there are just a couple of concepts to take away. This may seem like a lot of information, but let's pare it down to just a couple of things. There's pre-crisis planning, where you heard me mention the use of Medicaid trust or veterans trust. These are asset protection tools where it's possible to kind of have your cake and eat it too. You can transfer certain money to children or other relatives in a trust. You can maintain a limited amount of control over those assets. And at your death, the assets pass as if they were in a revocable trust or will. They pass at a cost basis adjustment, a step up in basis, assuming that Uncle Sam does not take that away from us. The assets that you transfer to these trusts are protected from the claims of the beneficiaries. So if you wanted to transfer assets to your children, for example, but you wanted to make sure those assets could not be lost to the claims of the creditors of your children, these trusts protect and allow you to get the money out of your name for Medicaid purposes, so we can get ahead of the 5-year rule. Many of you have heard of this, the 60 months for Medicaid. 60 months, if we divest our assets, we can be free of, under the current law, free of any kind of a nursing home spend down on those assets. In long-term care, we now have a very valid use of wills between spouses. So let's talk about this very quickly. Many of you either have an impaired spouse, God forbid, or you have relatives or friends that have an impaired spouse or loved one. Well, if we establish a will that leaves a trust for this spouse under our will, so we have a will, and if we die first, which may not happen if we are the well spouse, but if the well spouse dies first, we leave a trust for the disabled spouse. And under Maryland law now, we may leave assets into that trust as long as we leave a certain amount. And most couples leave everything in there, but not everybody. But as long as we leave a minimum amount, that trust is protected, and Maryland cannot recover for long-term care benefits paid for a disabled spouse. So between spouses where we have a disabled spouse, we've for a long time used a technique to protect that disabled spouse should the well spouse die first, protecting all the assets from a Medicaid spend down. Now, Maryland has a new law called the New Spousal Elective Share Law that now validates that strategy for the first time and says if you follow the rules of the New Spousal Elective Share Law, those assets are now protected, and Maryland absolutely has no right of recovery. So that's something we do in elder care. Now, in crisis planning, let's say we did no advanced planning, but we hopefully had very flexible powers of attorney or other documents in place, we now can save up to 50% of the assets. So we call that the rule of halves or the half-loaf strategy. So we have a crisis situation. We know that we can only save about 50% of the assets under certain circumstances. If we plan in advance and do a pre-crisis plan, we know that we possibly could save up to 100% of the assets that we're trying to save. Life estate deeds are used sometimes for this purpose. So we just want you to know that there is asset preservation or asset protection in the long-term care context. And as we wrap up, as I look at my time and I see that we only have a few more minutes left, but we are on time, thankfully. Now we're going to talk about asset protection at death. How do I protect the shares of my spouse, child, or grandchildren? So protecting spouses, is fairly straightforward. So let's pretend that I'm married and I want to make sure that if I die first, my surviving spouse has asset protection. Well, I can leave a trust for my spouse, and there are various ways this can be done. We just talked about a trust for a spouse in long-term care planning. This is a trust in more conventional planning. We might call this a marital trust. And there are various ways of looking at that. A very popular way of looking at it is something called the Q-tip trust, the qualified terminal interest property trust. But I leave assets for my spouse in that trust. It not only protects my spouse from the claims of creditors, but it also protects me and my children, let's say, if my spouse were to remarry, those assets do not go to a new spouse. Now, let's say at the death of my spouse or at my death, if I'm the second to die, or if I'm single at my death, I leave a trust for my children or grandchildren or significant other or whoever it may be. I can make sure that that irrevocable trust is spendthrift protected. That means that the claims of creditors against that trust are going to be foreclosed. The creditors cannot get into that trust. My beneficiary cannot give away his or her interest in that trust, and therefore creditors can't get in. Now, with asset protection, it's a very broad subject, of course, and we're making it very simple here for various reasons. But remember that there are exception creditors. So let's say that my beneficiary owed child support or alimony. That would not be protected by a spendthrift trust. Let's say my child or my beneficiary owed Uncle Sam. Uncle Sam would not be foreclosed from getting that money in that trust. But for all other basic creditors, we have spendthrift protection. There are ways of doing these trusts or structuring these trusts where the beneficiary can have the best of all worlds. They can be in control of their trust and yet still have spendthrift protection. And then there are arguments in favor of not having beneficiary control, and in some circumstances having independent trustees and so forth. So we just want you to know that it is possible to structure the beneficiaries control or not control, structuring spendthrift protection, structuring trustees, using special fiduciaries like trust protectors, using various legal techniques to make sure, like powers of appointment, to make sure that there's flexibility, but also making sure that creditors cannot get into the trust. And also, of course, protecting special needs beneficiaries. So here at Elville and Associates, we are very fortunate to have a very robust relationship with the special needs community and know here how to deal with the various special needs trusts, whether they're a first party trust, where the beneficiary has money in their own name and they should not have money in their own name, or whether it's what is called a third party trust. And this is the kind of supplemental needs or special needs trust where parents, grandparents, and others plan for the future of a disabled loved one through the way or method of a supplemental needs trust. So all of these types of asset protection techniques are things we want you to know about, whether it's lifetime asset protection, long-term care asset protection, or protecting spouses and children and protecting against remarriage and bankruptcy and so forth. All right, so we've wound down to the last couple of minutes, and I want to thank you for sitting through all of this information that we've taught this morning. Hopefully you've gained something from it. I'm going to turn it over to Jeff here in just a second. But one of the things we want you to do now is take all this information in, and what are you to take away from all this today? Well, client education is what we're all about. We think that you're not served if you're not being educated. Now, not everyone wants this level of education. Not everyone wants to engage in this kind of process. But we feel strongly, even if you want a very, very minimal educational process, and we can still do that for those who are more inclined to do that, we still feel that a very basic amount of education should be a part of every estate plan. So we invite you very warmly to meet with us. We do not charge for estate planning consultations. We feel that the first step is to just let Jeff know, or my assistant, Mary Gay Kramer, let Jeff know that you would like to set an appointment. There is no charge for the initial consultation. and then we figure out what is the best path forward. What are your goals? What are your concerns? What is happening in your life right now? Do we need to update old documents? Do we need to review old documents? We generally do not charge to review older documents to see where you are. And the first thing we do is send out a questionnaire to you. So we're going to send out a complex or comprehensive, I should say, questionnaire. And that estate planning questionnaire is really the basis of all good planning. And we realize that for many of you who have not done planning before or haven't done planning in a long time, it's a very odd experience to meet with someone, give them all of a stranger, give them all of your personal information. But remember, we would enter into an attorney-client relationship with you if you become a client. And all of that information is highly confidential between attorney and client. And it would be something that is very sacred to us, and we would keep that information safe. We have very elaborate systems here at Elville & Associates to keep your information safe. So we warmly encourage you to engage with us, to use us as a resource, and to come and consult. And Jeff will be happy to send you a questionnaire. So Jeff, I'm going to turn it over to you. I appreciate the questions today. I know we had a lot of people on this call, and I'm going to turn it over to Jeff and wish you a very, very happy weekend ahead, and I hope to meet you in the future.
Well, thanks, Steve. Thank you very much. We do have a couple of additional questions here at the end. So thank you very much for a job well done as always. So let's address these last questions before we adjourn, and I have my last final comments. The first question is from a good client of ours, Pauline, who you know, and that question is, can we make an advanced medical directive immediately effective in a COVID-19 situation, but with any other physical cognitive situation, make that effective only on the advice of 2 doctors?
That is a wonderful question. And my answer to that is, since the advanced medical directive is informal, for better or for worse, it's probably for better, it's very informal and it can be customized. I feel that as long as it's unambiguous, if your instructions are very, very clear and that we could, a reasonable person could draw a conclusion that this applies in this situation and this applies in another situation, I think that that could be done. Yes, so my initial reaction is to say, as long as it's unambiguous and very, very well done, I think it can work.
Thank you, Steve. Another question. There is more interest now in elder planning with staying in your home. What would you advise for a single person who wishes to do this with a will?
Thank you for that question. So my initial reaction is that, yes, we have a very poor situation in Maryland when it comes to the Medicaid waiver. If we had a robust situation with the Medicaid waiver in Maryland, which we do not right now and have not for years, a person like yourself could arguably plan to be able to stay home, and the Medicaid system would pay for your ability to stay home. In other words, why have someone living in a facility? So the Medicaid waiver has a long way to go in Maryland, and because of that, the burden is basically on the individual. So not knowing your situation or your financial situation, my initial reaction is to say that you plan for that situation with your will, very flexible and comprehensive powers of attorney and well thought out advanced medical directive, and then you form a collaborative team. So my mindset is you would have an elder care attorney, you would have a CPA, and you would have your financial advisor, and possibly you would have a life care manager involved as well. And these people are to work collaboratively. This is your advisory team. And we think, and I think, that you are best served. It's not for everyone, and there are costs involved, of course, to have a CPA and so forth, but CPAs are worth their weight in gold and some of their contributions to the group. And my thought is to generate the highest and best situation for you to be able to stay at home as long as possible and age in place. is a matter of very high level planning and collaboration. So that is my answer, and I look forward to talking to you about that and possibly meeting with you.
Well, thank you, Steve. And if you have any additional questions, this is certainly your time. I have a couple final thoughts. Thank you again, Steve, for a job well done. We do have a couple of other webinars that are coming up in the next couple of weeks. I wanted to mention to you, next Friday, we have our quarterly Estate and Trust Administration workshop, which has been very popular over the past couple of years with Steve Elville. Also, we have on December 16th, a new event. It is the financial planning aspects of estate planning with our senior principal, Olivia Holcomb-Volke. So we're looking forward to that. Advisors, again, if you would like continuing education credits, please get me your board ID and other information. If you could email that or call me with that, I greatly appreciate it. I'll also be sending out a copy of the presentation again for those that didn't get it. Also, I'll be sending the video link when that is available in the next couple hours. And I'll also ask that you kindly send out the responses to the post-webinar feedback that we're going to be sending out immediately after this webinar is over. So I will remain on the line for a few minutes. If you have any non-legal questions, I'm not an attorney, but I'd be happy to answer any other questions that you might have related to this webinar, setting appointments, any questions that you have about the firm in general. I am happy to answer those questions for you. So we want to thank you for being a part of today's webinar and your relationship with Elville & Associates. I hope you have a wonderful holiday and a great weekend as well. So let me check to see if we have any final questions. And it doesn't look like we do.
And I'd like to say happy holidays, everyone, and thank you for your attention this morning.
Yeah, let me just double check here. Nope, that's it. So yes, thanks very much, everybody. Have a great day. And thank you, Steve.
Thank you, Jeff.